First of all, I would like to congratulate and thank Professor Cheng and all the organizers of this scientific event, which is very up to date. I'm so glad to meet you again in good health, and it's a great honor for me to participate to this conference with my distinguished colleagues and friends. I chose the title of my address, Some Reflections on this strange category named Vulnerable Groups in the Coronavirus Context. The birth of the human rights marked the development by the international law of the recognizing of new categories with a special status, a special protection. So the justification and the legitimacy of this one are founded on the notion of vulnerability, more precisely the weakness, real or potential, of a category like children, women, or injured warriors. Seems to me the criterion of this affiliation. However, in a way, international law was the reflection of the law of the most part of the state, because domestic law provides separate provisions, special rules for these categories or other ones. As regard the legal approach, the weakness has to be analyzed as the shortening of the capacity to withstand an offense. With the Red Cross law, this trend is increasing in such a way that in the Fourth Geneva Convention of 1949 and in the two additional protocols of 1977, we find, for example, 40 times the word woman to protect them during the armed conflict, international or not international, against mainly the sexual abuse and rapes. Unfortunately, with the war in the former ex-Yugoslavia and the civil war in the Rwanda, the women don't monopolize the sexual offenses. It's turned a common practice against the women, men, and children. But we spoke still about victim. Whether the word has not disappeared for the international law vocabulary, we could remark that more and more the expression vulnerable person replaces this one. If considered the European Court of Human Rights cases in a shorter time than 20 years, this body used the expression in around 500 decisions. So this change of vocabulary shows the importance of the risk or the theory of risk in the new international law. Henceforth, all the branches of the international law gave endless and vulnerable person. The law of human rights, the war law, and the environmental law. In addition, the end of the last century launched some new concepts like the human security of the responsibility to protect, not necessarily accepted by the international community. However, we could underline a second change. Since after the vulnerable person, according to an individual approach, we notice the expression more and more use of vulnerable groups. During a long time in international law, we knew only the notion of minorities, but the judge has always declared that this status was a question of fact, not a legal issue. I would like at this stage of the reflection to point out several remarks. The first one concerns the judge of the European Court of Human Rights. He has always refused to recognize general rights of minorities. Nevertheless, it bans any discrimination based on the quality of member of the national minority, according to Article 14 of the Convention. The second remark is that the same judge spoke in favor of the acknowledgement of the groups, of the status of the groups, The jurisprudence of the gypsies is very relevant on this issue. And the last one, the most important, is a general query about, on one hand, the support of the affirmative action, and on the second, other one, the issue of the indivisibility of the human race. I'm not in a position to give a definitive answer to this question. I just note some trends, possibly strange and maybe dangerous for the unity of law. In regard to the branch of the international law known as the international criminal law, we could observe that the category of vulnerable groups has been strengthened by the provision of the rulings of the International Criminal Court, mainly by the International Criminal Tribunal for the Rwanda, concerning the definition of the genocide. This court, in order to define the concept of genocide, speak about the conscious destruction of the human group for national, ethnic, racial, religious grounds. More generally, if you consider the activity of the United Nations organization, the expression vulnerable groups appear in many official statements, documents, and reports. The United Nations peacekeeping action or the famine relief in case of humanitarian disaster suppose in the first time to identify the vulnerable groups to protect and to help. And in many cases, the right of life depends on the setting of these vulnerable groups, with the effect of the idea of the hierarchy and the competition among these vulnerable groups, a part of them having priority for geographic reason or ground of resources mainly. The government of the entire state, the World Health Organization, the medical world, and all the partners took and recommend measures to protect people's health and prevent the spread of this outbreak. In regard of the risk of mortality on account of the disease, a vulnerable group was identified, person suffering from severe acute respiratory symptoms. And in France, for example, all the national health campaign targets this group. However, concerning the recognizing of the vulnerable group, I want to point out two main contradictions and issues. According to the French official figures, the overwhelming majority of people infected have unfortunately died, as some elderly and obese men thought the obesity is the first risk factor, not the breathing difficulty, or this one are in the most cases the result of obesity. The French authorities warn the only person with respiratory symptoms. So could we think of the right of health care and the right for life in this case? The second issue concerns the health workers. They are the first line of any outbreak response, and as such are exposed to hazards that put them at the risk of infection with an outbreak pathogen. Each day, they risk an imminent and serious danger for the life of health. And in addition, the French relevant authorities provide adequate supplies in insufficient quantity to healthcare, masks, gloves, goggles, hand sanitizer, soap and wet water, cleaning supply. So more 6,000 of health workers has been infected and some dozen of them are passed away. So for us, we could regret that the right of life was denied. At the back of my mind, I believe that the first vulnerable group might be the health worker. They are deprived of the right of life because the negligence, the error of the French government. So over 1,000 of doctors for the moment are decided to complain against the state to endanger the life of health workers. And we could imagine that their lawyer will try to demonstrate that their fundamental rights are being denied and especially the right of life. So to wrap up, I invite Professor Cheng to organize in 2 or 3 years a special conference on the state responsibility for bridging the human rights in the coronavirus crisis. Thank you for your kind attention and keep safe.